Good evening and welcome to you all to a packed Senate room. Mark Shaw and I, who run the Durham Castle lectures, have to guess every week or every other week whether we'll fill the Senate room or the Great Hall. And tonight we underestimated the popularity of the talk, and that's why you're all crammed in. But I hope you enjoy this evening as well. And a special welcome, of course, to our speaker, Joppke. We're delighted to have you here. It's a real honor and a privilege to have you here this evening. Christian is Professor of Sociology at the University of Bern. His previous appointments include the University of Southern California, the European University Institute, the University of British Columbia, probably the most beautiful, and the International University of Bremen. His fields of expertise include the comparative study of immigration and integration policies, as well as religion, citizenship, and multiculturalism. And he's the author of over 100 significant publications, including, just to name some of his better-known books, Immigration and the Nation-State, 1999, Selecting by Origin, Ethnic Migration in the Liberal State, 2005, Citizenship and Immigration, 2010, steady themes here. We didn't just go with the time. And The Secular State Under Siege, 2015. But tonight he's going to talk about his most recent book, Is Multiculturalism Dead? And of course it's the title of the talk. I didn't know there was a subtitle, but now I see there is, but you can all read it. So please join me in giving our speaker a very warm welcome.
Yeah, I provide the answer why it isn't dead, along with my case here. This is actually a book that the press that is owned by, or co-owned by David Held asked me to write. So here is the argument in a nutshell. There has been a lot of talking and writing about a retreat, a demise, or almost a death of multiculturalism, multiple countries, multiple debates for multiple decades by now. But much of it more actually by way of a rebuttal that it isn't really the case than in the affirmative mode. The affirmative mode tends to be more in the realm of polemics, whereas the rebuttal are more in the mode of scholarship, as by Will Kimlicka and others. Now, much of this discussion, in my view, confounds multiculturalism with an explicit policy under that name, so that only countries that, like Canada, have it on the books, even in the constitution, could be called multiculturalism. This confounding obscures how liberal law itself and constitutionalism as the heart of liberal law requires multiculturalism, requires multiple ways of life that cannot and that should not be contained by a state, a liberal state that is to be neutral about people's ultimate values and commitments. How does one operate that? I guess that is the right one. Now, I dub this phenomenon of a multiculturalism, short of its name, I dub it legal multiculturalism or multiculturalism by liberal law. Indeed, constitutionalism, which is a higher law that protects individual rights from democratic majority preferences, assures that we live in societies that are set to be and to become more and more multicultural. And the case in point where I'm going to trying to plausibilize this idea is the empowerment of gays and Muslims, gays in the United States and Muslims in Europe. Now, this pairing may appear unusual, and whatever people may tell about me, in the end they always say, oh, he's so provocative. So wherever there is a provocation, that is something that is of interest to me. Indeed, this is a provocation, because, you know, in the real world, gays and Muslims are very much on opposite ends, very often clashing in terms of respecting or not respecting the right of homosexuality. So this clash in the real world between these two actors really obscures that the dynamic of their respective empowerment is very similar. In a nutshell, constitutions constrain majority power. In turn, they protect structural minorities that have lesser chances to use the political, the democratic process in their favor. But constitutions do that not so much through explicit group protections. No, they do it through individual rights clauses, especially liberty, freedom clauses, which posit the individual and not the group as the unit of integration in a liberal society. The only difference between these two cases here is that liberal law is more complexly involved in the Muslim empowerment case, where liberal law may also be not just empowering, but also a constraining force, particularly on certain illiberal claims. There's interestingly no such ambivalence about the role of liberal law on the case of gay empowerment. So that is in a way the road map, and I go plausibilize this argument in 4 steps. In the first step, a bit more flash on what is liberal constitutionalism and why does it engender multiculturalism. In the second step, the gay case in the United States. And in the third step, the Muslim case in Europe. And in the fourth and round up moment, a little bit of comparing and contrasting. Let's start with liberal constitutionalism. What is liberalism? Let's start with liberalism. There's so much writing on that. A great book recently appeared by Edmund Forkett, who I think is a Financial Times editorialist. It's a very good book, and he calls liberalism respect for people whatever they think and whoever they are. Respect for people, whatever they think and whoever they are. Elementary respect for the individual is the reason why a liberal society cannot but be multicultural. But it is left because, and why? Because it is left to the individuals and not the state to define what kinds of life people want to live as individuals as much as in groups. There is, of course, a public morality in a liberal society, but what is to be protected by it under its laws is not, as it was once the case, corporate entities, religion, nation, family. That is the past. Today, Public morality, to the degree that it still exists, protects the individual herself. And indeed, Durkheim had already pointed that out. Individualism, he said, is the only system of beliefs which can ensure the moral unity of the country. The liberal state is neutral in the precise sense of making the integrity of the individual the linchpin of public morality and order. Neutrality, as one liberal philosopher put it, is the best term to describe the minimal moral conception of liberalism. So liberalism, our first concept to work with, thus understood in this way, Judith Sklar has observed it very nicely. Liberalism, thus understood, does not have any particular positive doctrines about how people are to conduct their lives or what personal choices they are to make, in that famous essay on the liberalism of fear. Indeed, this liberalism is a liberalism of fear that protects the individual from the summum malum, the biggest possible calamity of arbitrary state and group power. Liberalism in this understanding is closer to constitutionalism, to the idea of constitutionalism, than to the idea of democracy. There's a classic paper on constitutionalism from which I learned a lot in this immense literature by Giovanni Sartori in the 1960s. That paper qualified as constitutionalism a system of protected freedom for the individual and of restricting arbitrary power. Now, in a democratic context, constitutions constrain majority power. So there is a tension between democracy and constitutionalism. We tend to be used to this notion of liberal democracy, as if these two components go naturally together. In reality, they are not of the same cloth. Judith Sklar, again, from whom I learned a lot in that respect, put it well. In that famous essay, she says, liberalism is monogamously, faithfully, and permanently married to democracy, but it is a marriage of convenience. Now, to the degree that certain individuals can never hope to ever attain majority status, democratic majority status in society, we arrive at the concept of a minority and a special protective attention to minorities under constitutionalism. The book which best brings home that point is by an American legal scholar, John Hart Ely, a book called Democracy and Distrust, which talks mostly about jurisprudence in the United States, but I think this logic of constitutionalism as being geared to protect minorities applies more generally. So according to Ely, the function of judicial review, that typical function of particularly the highest echelon of the judiciary, the constitutional courts, the function of judicial review is the protection of minorities from majority tyranny. And he then coins that famous concept of discrete and insular minorities, which are to be especially protected by constitutional courts. Now, this is the American story, but I think something similar is also observable in Europe, a strong legal multiculturalism, European style, which I will explore along the Muslim case. So however bizarre this pairing of these two groups and their respective empowerment may be, they have something in common. And what they have in common, which justifies a comparison, has been very nicely described by Joseph Carens, a Canadian political theorist. He says these groups, these two groups, what they have in common is they are vulnerable minorities whose identities are often denigrated by members of the majority. So that is the first idea here. I will go back to this Kimlicka entry later, so I will not bother and lose time with that here. I jump right into the first story of gay empowerment. Here, there are two within gay discourse, or with a gay movement, and gay for me is just shorthand for gay and lesbian. There are two competing ways of understanding that quest. One is more in an ethnic direction, as a specific group that is to be equally protected by the laws. But there's also a very radical strand, the queer strand, which is actually critical of traditional identity politics, is in a way it's reductio ad absurdum, in a way catching the homosexuality in all of us. Only if that is successful, then real liberation, sexual liberation can occur. So that is in a way competition, a struggle within the gay movement of how to understand their quest for emancipation. And you will see how this was then conditioned and channelized by the legal context into a specific direction, that the queer mode had to be suppressed because it's very difficult to articulate the queer quest as a post-identity politics within the context of at least American constitutional law here. So the group then moved into an ethnic group empowerment direction, not on the basis of any fancy multiculturalism policy or such, but just exhausting what the American Constitution has on offer here. And it has on offer two essential principles: the freedom principle, the due process clause as it's called, and the equality principle, the equal protection clause in the American Constitution. I will go into it. One may, before I go into it, question that gays and lesbians are a multicultural actor to begin with. Kimlicka, for him, within his scheme of minority rights, gays and lesbians are not part. They're outside. And it is because of a, in a way, nationalist understanding of what groups are. Only groups that are institutionally complete, in a way, can produce their own offspring. Are groups, whether in the majority mode, then we don't have to care about them, they are protected anyway, or in the minority mode, then we have to get into action or into writing on Kimlicka's part. It's even both in his personal case. So he denies that gays and lesbians are a multicultural actor to begin with. Then my comparison, of course, would be totally nil. You couldn't compare apples and oranges, as it were, right? But I do think Kimlicka is a bit too narrow here. So I then use the gun of Nancy Fraser, who wrote a very famous article on comparing the politics of distribution with the politics of recognition. And of course, recognition is this quintessential multiculturalism politics against traditional class politics, which is about filling your pockets with money. And Fraser, in Fraser's logic, gays actually are the clearest case of recognition, because gays can be found anywhere in the social hierarchy. You know, there are rich gays and poor gays. So they are not a player in the politics of distribution. They are exclusively a player in the politics of recognition. So with Fraser, I think it's if there's only an inch of truth in that, and I think it's a very nice observation on her part, then it is clearly justified to have a comparison of gays as a multicultural claimant. You know, it's too dark here, so I will just try to get it out of my brain here. This gay rights story, interestingly, it is a legal drama. The gay movement was not in the streets. There was street action at one point in the famous Stonewall Inn, right? This famous bar there in Lower Manhattan. But the real action really happened in the courtrooms. And it's actually quite interesting to see that the smartest judicial reasoning about gays and how they can use the law to improve their position has been done by activists. People like Yoshino, a brilliant lawyer from New York University, or there are others. So it's quite interesting to see how important actually judicial reasoning by very smart brains at Harvard and at NYU has been for launching the real world movement and the real world successes of gays and lesbians. And indeed, the infamous point of entry here has been a decision by the American Supreme Court in 1986, Bowers versus Hardwick, which accused two guys who had engaged, they were caught in sodomy, of breaking the law of the land, which I think it was in Georgia, prohibited sodomy. Interestingly, not just homosexual sodomy, but also straight sodomy. But in this judgment, gays were singled out for punishment, and interestingly there was a complete silence on that. The law actually also prohibited straight people's sodomy, but they were not an issue here. What the court there decided is there is no right to privacy for homosexuals, therefore their sodomic acts are subject to be punished by the law of America. One must know here, the right to privacy is something that cannot be found anywhere in the American Constitution. It is a so-called substantive due process right. It has been read into the Constitution on the basis of jurisprudence by particularly the highest court. And the right to privacy, its most famous blossom has of course been the legalization of abortion, where it was simply considered the right of the woman to control her body that justified to abort unborn children. But when the right to privacy was introduced as a substantive due process right, that was still 15 years in the making to arrive at the famous abortion case. In the beginning, it was stuff like contraceptives, which were not legal at the time, whether in your private precincts you were allowed to use them or not. Now, this right to privacy here was denied to homosexuals. An interesting reasoning on the part of a very grey old man's court who came up with that judgment. The crime of homosexuality has ancient roots, it was said there, which is pretty much baloney, because we know from Michel Foucault and other historians that the homosexual persona is actually an invention of modern medicine of the 19th century, and modern psychiatry and psychology of the 19th century. Interestingly, why did the judges argue there is no right to privacy for gays? The argument was essentially, we as judges, we are liberal judges. We cannot decide such an issue. It is for the people of Georgia, or whoever was the state which was in charge here. If the people of Georgia, of the American state of Georgia, so decide that homosexuality is to be punished, then it is punishable. Because in a way, majority preferences, what they consider to be the legitimate way of life, have the status of being the law of the land. So it was not a substantive condemnation of homosexuality, it was a procedural condemnation of homosexuality, which is very interesting and an interesting nuance here. Now, the gay movement, how did it respond to this terrible blow of Boas versus Hartwig? When the judgment was made, the gay movement was all into conduct liberation. In a way, it was to say, queer, give up on the idea of identities as scripts, have sex with a woman at noontime and sex with a man in the afternoon, almost like Karl Marx dreamed about the communist paradise in the German ideology. And for that, one would have legally needed strong liberty rights, substantive due process rights. One would have needed the right to privacy, which was exactly denied by the court in this judgment to homosexuals, gays. So the movement then shifted in a way from we see it does not work to make the liberty principle work for us. Let's try the equality principle. Let's try that the status of homosexuals cannot be treated in any worse way than the status, say, of straight people or of any group in society. So the gay movement responded to Boas versus Hartwig, moving from conduct to status protection. Unfortunately, it did not work. Because logically speaking, it was never illegal to be gay. What was illegal was to engage in sodomy, in anal sex, basically. So the courts then, who kind of got a lot of equal protection claims by gay movements and brains and both civil society and legal scholars, the judges said, look, okay, it is not illegal to be gay, but to be homosexual means to engage in anal sex, and exactly that was denied in Boas versus Hartwig. Ergo, you cannot protect the status of the group of a group that engages in illegal conduct, in illegal activity. So there is a status conduct conflation that kind of thwarted, cut through this attempt of the gay movement not so much to exploit the freedom, the due process clause of the Constitution, but the equality clause, the equal protection clause of the Constitution. At that time, there were a lot of initiatives, mostly in progressive cities like Austin or Berkeley or Cambridge, which would declare more symbolically that gays are just one of the protected minorities against which you must not discriminate. Interestingly, up to the present day, gays and lesbians, that means sexual orientation, is not legally protected under American law. European law in that respect is much more advanced. There would be no question the European Convention of Human Rights or in domestic constitutional law that sexual orientation belongs to the protected ascriptive markers of minority groups. America, unfortunately, isn't so far. So the gay movement strategy shift didn't work because of that problem of conduct conflation. Now, the big bang was Lawrence versus Texas. Much more important, actually, than the Supreme Court decision that liberalized or that legalized homosexual marriage, which happened only in 2015, I think. That happened already in 2003. Here, the court made, if you want, a U-turn. The right to privacy was restored. Interestingly, the claimants had tried, following this shift of the movement from going high on the liberty clause to going high on the equality clause, the court did not move with the movement here for legal, technical reasons. So in a way, Boas versus Hartwig had to be undone. And this is what Lawrence versus Texas gloriously delivered. The right to privacy applies to homosexuals, contrary to Boas versus Hartwig. There is very lyrical language here. If you read, it's a beautiful majority opinion written by Kennedy, Anthony Kennedy, the swing vote, even still today on the court. He's aging, and if Kennedy leaves, then it will be a dark age under Donald Trump. He will make sure that that will really then be a majority conservative court. So Kennedy wrote, it's not actually the homosexual act, the sodomy as such, which is protected under the substantive due process clause. It is the relationship, the intimate relationship between two individuals. And then there's very lyrical language, as I call it, to flowery language to describe the relationship that the state must never mess with. There's a lot of interesting use of the language of respect, of dignity, which are in a way the typical multicultural concepts, right? Respect and dignity of a historically denigrated, trampled on minority group has to be restored. So there was, even though the main legal reasoning was on the substantive due process, the freedom clause of the Constitution, there was a minor key of equal protection, and in that sense of classical multiculturalism, to the degree that the principle of equal protection and equality is closer to its cause than the principle of liberty. Now, I interpret this move from Boas versus Hartwig, this homophobic, one really has to call this judgment homophobic, to this liberal decision. I call it, what happened in the meantime is kind of a thinning of public morality. That indeed it is not majority opinion that should impose its lifestyle on all groups in a diverse society. This is overbearing. It is even an illiberal concept to begin with. The thinning of public morality is, in a way, and particularly the thinning and the removal of religious precepts within public morality is the big background story to the possibility of liberalizing this morals restriction or this morals legislation here. There's a famous legal debate. The most famous legal debate of the 20th century is between Patrick Devlin, High Court Justice in England, and H.L. Hart. And Devlin, in this debate, had made this point: there is public morality. That is what makes society more than just a sack of potatoes. And if there's meaning to democracy, it is the right of the majority to impose its public morality, its lifestyle, if you want, on all. The people on the Clapham omnibus, they are the ones who kind of call the shots and should tell everyone in society of what is the proper and the decent way to live. That has gone out of business, and in a way the Hartian, classically liberal line that public morality cannot be legislated has been very effective and come to the fore here in this judgment. Okay, I think I leave it at that and move. How many more minutes do I have? 15? 25. Okay, then I don't have to rush that much here. The difference, and a lot of nuance, I'm afraid, gets lost in this brainstorming exercise here, and I simply refer you to the book. It's also published as an article in the European Journal of Sociology. So I leave those who are interested in for the details. I leave you to that. The one difference between gay empowerment and Muslim empowerment is that liberal law, particularly constitutionalism as its beating heart, is not and has not only been a resource for Muslims, has also been a constraint for Muslims. And I will get to that crucial point of difference in a minute. There have been two sources of legal empowerment. In fact, not just constitutional law, which was the main story for gays. Also, one has to consider a separate legal factor, legal pluralism, which to a minimal degree exists in every society, and particularly in a liberal society. I will come to that in a second, because this legal pluralism has two components, private international law and civil law. Now, let's start with constitutional law. Here, the most important source is religious freedom clauses in the Constitution. Not just in state constitutions, but also in the European Convention of Human Rights, the famous Article 9. In the German, I look at the German case here in particular, even though I make the statement it's intended to be applicable to cases beyond Germany, but in a way, from the logic of comparison, Germany is a critical case in the sense that at the political level, Germany has never understood and defined itself as a multicultural society. And many of you will have heard the famous remark by Angela Merkel that multiculti has totally failed and we have to move beyond that. But this is just kind of rhetoric that hides the real story, and there are various real stories of how Islam could kind of routinize its position and stabilize its position in German society. But one here that is particularly interesting and important is the role of constitutional law. This religious freedom clause in the the logic of comparison is, if this multiculturalism by liberal law can be observed in the case of Germany, which politically is not multicultural, then there is a strong presumption that it holds to other cases as well. That is why Germany is such an interesting case here. And here the main source is Article 4, which protects religious freedom. It's a very strong provision. It doesn't need any statutory implementation. It can be kind of directly applied. From the level of constitutional law, which is a bit unusual. A lot of other constitutional clauses have to be first domestically or statutorily implemented before they can become effective. It is protecting actually not just belief, but also religious practice. So a collective dimension of religion is automatically protected. There's a lot of, in the literature, critique of secular law that can never do justice to Islam, because secular law is individualistic. If it comes to religion, it protects only beliefs, but this is a very Protestant notion. Islam requires orthopraxy, it requires to be in the streets in a way, literally, figuratively speaking. Saba Mahmoud, quite well-known anthropologist from Berkeley, has very strongly made that very polemical, total broadside against secular law, which could never do justice to a religion that is different from the Protestant mainstream. This is all rubbish. It's really all rubbish, because this clause includes a collective dimension which is equally protected. Not just the Protestant version is protected. And there's absolutely no question that this religious freedom clause applies not only to Christians, but applies to all religionists, wherever they may come from, and to whatever what God they adore. It applies to all of them. And German law, then in reality, is extremely permissive with respect to Muslim religious practices. If a mosque is to be built, there is a deliberate line that say, if a mosque is to be built, that means a lot of noise early in the morning, because the morning prayer is before dawn, right? So there is, in a way, justified fears of neighbors. If the new big mosque project in our residential neighborhood, then you will be driven out of sleep at 5 o'clock from the cars that try to find a parking place, and the honking and stuff. And here, German courts would argue, religious freedom is so important that the interest of neighbors in nocturnal peace is waived by the importance of religious expression. So it is a very, very strong clause. There is always the reference to headscarf restrictions, which is then used as an example, or as a trophy to say liberal countries are bad to Islam. But at least in Germany, and I think it's the case in many other, Britain anyway, there is a very strong headscarf permissiveness. Headscarf permissiveness, here one has to be very careful and precise in one's reasoning. One has to distinguish where actually is the headscarf producing a conflict. Is it at the private work space, in the corporate sphere, or is it in the public sphere? Interestingly, most trouble And most debate is about the headscarf in the public sphere, not in the private sphere. In the private sphere, things most of the time work very well, not by making big declarations about the importance of religious freedom, but informal, implicit, indirect solutions are found most of the time, and at least in the case of Germany, the highest court, the highest labor court in the country has fully validated that point. There is now a little bit more ambivalent decision on that for the first time by the European Court of Justice. If you want to have that debated, I refer you, because it goes in a slightly more restrictive direction. But I think I have a plausible explanation for that, that it still fits with the overall liberal picture that I'm trying to convey you here. But back to the headscarf in the public sphere. In Germany, of course, it was never in question that pupils are allowed to wear a headscarf out of their religious liberty interest, or because the parents have the right to educate children in their way, and that is also protected in the basic law. Now, it was only teachers who were in debate. Teachers, and not just teachers anywhere, but public school teachers. And public school teachers in Germany are civil servants. They are Beamte. If you're a Beamte, a civil servant, you must swear an oath to the Constitution, and you must defend the interests of the state, and you must kind of support the neutrality of the state. And I think here you can make a reasonable argument that religious dress is in conflict with the neutrality mandate of the state. That, of course, does not apply to the clients of the state, but to the paid employees or the representatives of the state. So there are two big headscarf judgments of Germans of the German Constitutional Court. The famous Ludin case in 2003 or something was a bit of a Solomonic judgment. It said, this Article 4 is so strong that if there is no state law kind of prohibiting religious symbols, then it will always prevail. But somehow, if the states and the Länder, sub-federal states, are in charge of dealing with this matter here, think that a more French solution to the issue, that is a kind of laïc, strong, powerful neutrality, and not this open, embracing pluralistic neutrality that is traditionally the German way. If the states so decide that this is the better way of proceeding, in a way not in the traditionally de facto multicultural German way, open neutrality, but then they have to legislate. But short of such legislation, the teacher is allowed to wear the headscarf in exercise of her Article 4 religious freedom right. As a result, of course, starting with Bavaria and with Baden-Württemberg, the conservative Länder all passed restrictive laws that prohibit religious wear on the part of teachers in public schools. And very infamously, an exception was made for Catholic nuns. In some parts in Germany, Catholic nuns are school teachers, publicly employed in public schools, and so they had to come up with a trick that a religious prohibition, which is notionally has to be universal, still allows these nuns, nevertheless, to get around the law. And the trick was to argue, look, religion is not just creed. Religion is also culture. And Christianity is majority culture. And the state somehow, one of its mandates is to instill this majority culture on all of its citizens. So the nuns in the classroom, they are not in a way creedally wearing the hood, but they represent Occidental culture. It's an absurd construction, which the very court, the Ludin court, had already in one passage excluded such a reading. But that was 2003, but it was still not an entirely anti-multicultural ruling, because there was a lot of saying the headscarf cannot be reduced to be a symbol of male oppression. It can also be the sign of female emancipation. It just depends. The meaning of the headscarf is context dependent. And the German Constitutional Court was quoting, to make that point, Nilofer Göhle's book, where there's a famous study on the veiling movement in Turkey. She's a kind of hip Islam scholar in France. Now, 2015, a new judgment is made, where in a way the court makes a U-turn. The court now argues very strongly, only if the headscarf in a concrete instance endangers school peace, that is the pedagogical enterprise, only if it is a concrete danger, not already because it is an abstract danger that puts at risk the neutrality of the state. Only if there's a concrete demonstrated impairment of the pedagogical enterprise can the teacher's headscarf be prohibited. Period. It's really a quite dramatic U-turn. No longer does the court say whether the French solution or the German solution, the states have to decide. No. The court now says Article 4 is so strong that there is no escape route for the states through moving in a French direction. In principle, the headscarf of teachers is legal now in Germany. And also, of course, that is more the side effect, this bizarre construction that nuns represent German culture if they have the hood and are not exercising their religion. That is declared a breach of the equality principle of the Constitution. It's discriminatory, so it is outlawed with them. To me, this latest German headscarf decision is a powerful demonstration of the workings of legal multiculturalism, a multiculturalism that doesn't need the explicit word. The word is denigrated also in Germany. If the Germans want to say something in a multicultural direction, in a positive mode, they would say intercultural. And anyone in the room, if any one of you can enlighten me about the distinction between inter as against multicultural, then I will fly home tomorrow morning with being really a good deal brighter than I am at this point. Okay, that is the constitutional law story. The legal pluralism element, that's a bit technical, and I think I will leave it out here. Private international law deals with conflict of laws. Say you get married under Sharia law in Egypt, and then you move as an immigrant to Germany, and you want to divorce. So the question is, now which law does apply? Is it Egyptian, Sharia, Islamic law? Or is it German secular law. And here, private international law, in principle, argues the Committee of Nations, that's a famous legal principle under private international law, the Committee of Nations, kind of the peaceful coexistence of nations, requires that an act that is legal in one country is considered to be legal also in other countries, unless there's a breach of public order. There is a public order firewall that prevents, in a way, to have, say, polygamy or genital ritual cutting of genitals and all of that, particularly on the part of females, to have that. So there is a firewall in terms of the public order principle. But interestingly, and then Saba Mahmoud argues this public order proviso, you find that in the Egyptian constitution, you find that in the German constitution, and in each case it is just the descriptive majority preferences that are endowed with power here. This is not really accurate, because a precise reading of the public order proviso that is in a way a constraint on an extreme laxism and liberalism with tolerating different ways of and understandings of marriage and of family relations, etc. The public order principle in Western state constitutions, in a way, is identical with the protection of elementary human rights. And the public order principle in Islamic majority countries protects Islamic law as Islamic law. It's a fundamental difference. I advise you to read this newest book by Saba Mahmoud, which is a brilliant book, case study of Egypt and how minority religions in Egypt have a terrible hard time, from the Bahia sect within the Islam to Coptic Christs. And this is all the story of, it has nothing to do with Islam if they're doing badly in Egypt. It's all because they copied the idea of secular law and the principle of public order that then restricts religious freedoms. It's really a way of arguing that Hegel would say it's the night in which all cats are gray. So the public order principle is the protection of elementary human rights, completely different than using the public order principle as enshrining what is majority culture or majority religion in some Muslim majority countries. And then there is a story of optional civil law that allows the possibility of multicultural outcomes. Civil law is different in its logic from penal law. Civil law gives a lot of space to the negotiation of the conflict partners, if the conflict partners agree to it. Penal law, we know that as sociologists, at least since Durkheim, is in a way society doing the revenge against fundamental violations of the basic order. So penal law kicks in even if the involved conflict partners would say, I don't want that the guy who raped me is now put into prison, so I withdraw my... No, the state will prosecute because it's penal law, it's not civil law. Civil law allows possibilities for other sources of conflict resolution, Sharia, to become institutionalized. And the way Sharia law has become institutionalized through this angle of civic law or civil law is a very interesting one. And I describe that along the British case, because Britain, like some other countries, have so-called arbitration laws. And arbitration laws are kind of the point of entry for civil law engendering multicultural outcomes. Under arbitration law, it wouldn't be secular law, say, that decides about divorce cases, but it would be Jewish law or here Islamic law. So I have an interpretation and I have an opinion on all of these Sharia councils, which actually is surprisingly, how to say, positive about them, but I will leave that for later or not at all in this context here. Now, the last point, Muslims in liberal Europe. Liberal law not only as a resource of empowerment, also as a constraint. Because, I mean, liberal law, basic principles, freedom, equality, there are certain Islamic claims that not only from a polemic Islamophobic perspective may be problematic. Should we really suppress literature? Should we really suppress the satanic verses only because the prophet is depicted there in a less than pious way? Should we really let it go that women are not always treated as well, at least in traditional Islamic context, as they are very often treated, not perfectly, but surely approximating the principle of equality in secular settings. So there are moments in which the basics of liberal law, freedom and equality, to use only these two big signposts of liberalism as such, and liberal law in particular, can come in conflict with certain Islamic, at least extreme Islamic claims. Now, even here, in principle, the story is still very positive. One has to distinguish here between equality and exemption claims made by Muslim groups. An equality claim means I want to be treated as an individual and as a group exactly as people of the majority religion are treated. An equality claim is impossible to deny. Impossible or very, very difficult to deny. It's a bit more tricky with respect to exemption claims. Exemption claims are claims, we know there are laws that require animals are to be stunned before they are killed in order to minimize their suffering. That's the law of the land for the sake of animal protection. And then come Jewish groups and Islamic groups which say, but my religious diet requires that the throat of the animal is cut with a sharp knife and then it's bleeded out and bled out, and that's halal or kosher food, and that obviously doesn't allow to stun the animal before it is killed. And a lot of animal protection groups then say, but that increases the suffering of the animal. It's a big debate. I will not take position here also because I'm not qualified to that. Exemption claims are a bit trickier because to use actually the halal and religious slaughtering exemption claim, it worked quite well for Muslim groups in many countries, not in all European countries, because a Jewish precedent, and to the degree that a Jewish precedent already exists, then it's impossible actually. If kosher food production is allowed, it's impossible to deny halal food. Of course, if kosher food production is not allowed, then it's much more difficult for getting the halal claim, the Islamic claim, realized. So exemption claims are a bit iffier here, and one can even see, to a degree, there has been a certain conservative turn on the part of courts when they have to adjudicate on exemption claims. And the Paradebeispiel, the best example, is co-educational swimming lessons in school, in public schools. Here, in the 1990s, up to the 1990s, courts throughout continental Europe, including Switzerland, Germany, in almost identical wording said, look, if parents, out of their religious convictions, think their child should be withdrawn from co-educational swimming lessons, where, say, a girl is exposed to the sight of a boy in tightly cut swim dress, right, and a small badehose, if that is against their religious ways, so be it. So be it. And okay, there's even one line in the German Federal Administrative Court decision, a famous one, which says, yeah, well, if parents of Muslim kids want to educate their children in a way that is absolutely not compatible with, say, the dominant way in which you have sex very early and you have no anxiety to see nude bodies. It's just fine. It's their good right to have their kids educated in their own image. Now, such a position is totally against the idea of integration. And there is even a constitutional requirement of the state, die Erziehungsaufgabe, as it's called in German language, the educational mandate of the state to educate emancipated, modern, quote-unquote, citizens, which requires that you're at ease if you're man and woman, and to shake hands and all of that, right? There is an obligation of the school to integrate society. It's before the entire integration debate happened and even the concept was up. That is in the German constitution, here exemplary for other state constitutions. And in the old glorious, really multicultural days, there was total neglect that religious freedom rights or parental education rights, individual rights here, could in any way be restricted. By the integration mandate of the public school to educate autonomous citizens. And now, since we have an Islam debate, even the highest constitutional courts have become very much conscious. There is a conflict between two equal constitutional principles here: individual religious rights and kind of the interest of society, call it that way, to be cohesive, to be integrated. And it's the requirement of courts to adjudicate when in a concrete case one principle should prevail over the other, because you cannot always have it both ways. And here is a great decision, in terms of, I don't necessarily support it, even though I think it's also a good decision, a great decision because it brings this conflict here between two equal level constitutional principles very nicely into the picture. The Burkini decision. What was that decision? It's actually also came to the European Court of Human Rights. I still have 5 minutes. I'm totally spaced out from...
Are you going to get into the compare and contrast?
Yeah, I think I should do that.
Yeah, I mean, it might be a good idea. And then perhaps...
Right.
After 5 minutes, so
good point.
we can have some discussion.
Good point. Yeah, these are convergent stories of legal multiculturalism. What are the divergences? 3. In the case of gays, in a way, cultural change preceded legal change. That is not the case with respect to Muslims in Europe. You have a lot of progressive legal change or legal decision making, legal empowerment, all which I glorified in the past too many minutes. But society is Islamophobic. I don't like the notion of Islamophobia for a second. I think it's a very misleading notion in so many respects. I will not debate it here. But what is clearly a fact is that the majority of Germans say, to use the German example again, my colleague from Erfurt, Kai Haffetz, who wrote a nice book about it, called the Germans the reigning champions, the reigning European champions in Islamophobia. And indeed, public thinking is not good. So what you see here is legal change in a way being ahead of cultural change, which has not yet occurred. And that gives and because there is this disjunction between lacking cultural change and a lot of legal change, because of this disjunction, you have the phenomenon of extreme right-wing parties who excel actually in expressing what a CDU woman like Angela Merkel, she said, Multikulti ist gescheitert, but she didn't blame Islam. Angela Merkel would also have said, Islam is a part of Germany, almost in the same breath. Not in the same speech, but in the same breath almost. So the mainstream is totally politically correct. It does not for a second coincide with what ordinary people think, who are very Islamophobic. One must see that. And that provides the vacuum which is used with great effectiveness by the parties, you know the names, from the Front National to the Alternative for Germany. The gay story is completely different. It seemed to be, before there was legal change, at least in America, there was dramatic cultural change. That I see it with my own children. Look, I'm now 58, I'm almost in the Gruft, right? I, as a young man, I remember gay is kind of strange. To me, I was not originally at ease with my children. They are totally at ease with the fact of some kids are kind of more gay and others are not. There's a dramatic cultural change, cultural social change among the young generations. And there's interesting sociological work that tries to explain it. I cannot reach that out here. So there's a complete opposite positioning here of the cultural and legal change components in this overall emancipation story of gays and Muslims. Now, the second point, special versus equal rights. One could argue what gays want is not special rights. They just want equal rights. And who can deny that? Who can deny that, look, if there's marriage, why should it be only between man and woman? Because it's written in the Bible. Is the Bible the law of the land? Or is the law of the land the constitution that says kind of equality of man and woman, equality of sexual orientation, etc., etc.? So in a way, the gay empowerment is an equal rights empowerment, makes it a little bit lame duck. And the Muslim case appears always as special rights. They want a special deal. This is why Christian majority groups, to the degree that they exist in Europe, may have an issue with that. They always want an exception. They don't want to send their kid to the Klassenfahrt, to the class outing. They don't want to participate in the swimming with all the others. They want their special. They want to build their parallel society, their Parallelgesellschaft. Now one has to be careful here. These are not special rights that these Muslim groups claim. They are really higher order individual rights that, for example, are religious freedom rights. That point has been made by Jürgen Habermas, who, as you know, was very critical of Charles Taylor and this idea of politics of recognition. Habermas argued special rights in reality are higher order individual rights that trump statutory laws or that trump public order rules. In that respect, there isn't really a difference here between Muslim legal claims making and gay legal claims making. I leave it at that. Thinning versus thickening of public morality. I made the thinning of public morality the background story to explain the surprising ease with which, in a way, gay liberation could proceed with respect to Muslims. And that's a critical, I'm sometimes attacked for being totally naive about the self-producing powers of liberalism, as if liberalism was all good and as if there were not also shadow sides, shadowy aspects of liberalism. What is the shadowy aspect of liberalism? In a way, there are two liberalisms, which is the topos in the literature. John Gray wrote about it, many others. It goes back into political history of ideas many centuries back. There is a liberalism that says liberalism is about setting up rules of the game for different individuals and groups to peacefully coexist. It's a toleration liberalism. It's the English liberalism. It's the really multicultural liberalism, if you want. But then there's a second liberalism. It's the French liberalism. It's the idea, I use this notion with gusto here, the liberal state is only for a particular type of people, liberal people, and all others better stay out. Yeah? Liberalism for the liberals, cannibalism for the cannibals. This is identity liberalism. It's a kind of liberalism that makes liberalism a weapon to beat Muslims with. And here one can see that what is observable in European societies in particular is a thickening of the liberal public morality, where liberalism is in a way denatured from being a toleration creed to becoming an identity creed. And that is the big risk that Europe is facing today, to kind of juggle that indeed liberalism needs both elements. It needs an element of toleration and it needs an element of identity. And in recent decades, the identity component has overshadowed the toleration component. Examples are these civic integration policies for newcomers, citizenship tests, which in some incarnations have rather illiberal elements to it, ironically for the sake of defending liberalism against the illiberal threat that comes from hypostasized Islam. I think I leave it at that.
Okay. Well, many thanks, first of all.